What's up, everybody? Welcome back into another episode of The Lawyer You Know. We had an early end to court today, so an early start to our video. I'm heading out on vacation in a couple hours, but wanted to talk to you guys about the day in court today. Not a ton of witness testimony necessarily from Welcher, but a lot happened, specifically in the beginning of the day where the lawyers argued about what content they could ask Dr. Welcher about and what that judge's ruling was. And we'll talk about whether I agree or disagree with it and why. And then at the end of the day, they play yet another clip from Karen Reed. How damning is it? Will that be evidence that will convince jurors of her guilt? We'll talk about that. And of course, everything in between, as the demeanor was very different in the cross-examination today, I thought, from Welcher and from Alessi. We'll talk about what you guys thought, answer your questions throughout this video. Make sure you guys hit the like button. Let's get started. So we started the day where we ended yesterday, which was, can the defense ask Dr. Welcher about Trooper Paul's report, analysis, testimony, and about Dr. Scortibello's report, analysis, and testimony? And yesterday, Alessi was kind of making arguments off the cuff, and it was fine, but not nearly as in-depth and correct, and he was not able to call Hank Brennan out yesterday with what I thought was some very good arguments by Hank Brennan, right? I thought Hank Brennan made some great arguments yesterday. That's not even Trooper Paul's drone picture. That's from CERT. You didn't rely on Trooper Paul. You didn't rely on Scortibello, did you? And of course, he said no. So it seemed like round one went to Hank Brennan. It was very clear when we get to the judge's decision and how quickly she made it today that she had already made her decision prior to the arguments this morning, but she still allowed the lawyers to argue for the record. And Alessi started out with some very clear arguments that, regardless of what Dr. Welcher says, he very clearly used and reviewed Trooper Paul's report, documents, adopted them, used them, put them in his PowerPoint. The details he got from Trooper Paul was how he started and was kind of the anchor to a lot of what he did. I thought he made a pretty compelling argument to that. And then we get to him calling out Hank Brennan and saying things that just were frankly not true, according to Mr. Alessi. Now, is Judge Cannone going to care? Spoiler alert, no.
In the cards team. Last point with regard to the Trooper Paul basis in adoption of Dr. Welcher. Mr. Brennan asked Dr. Welcher on voir dire if the image from slide 36 actually came from the CERT team, which is simply not true. The CERT team, actually Lieutenant Tully with the CERT team, took about a dozen photos of the taillight in the snow in the dark around 6 p.m. on January 29, 2022. Lieutenant O'Hara said that the CERT team never traveled back to the scene again. So there were very obviously no photos or images taken by the CERT team in the daylight from the drone. And I again refer to slides 22 and slides 23, where Dr. Welcher said it was more likely than not that it was Trooper Paul in those slides, but the point, whether Trooper Paul or not, is completely overwhelmed by what I just argued and presented as specific factual basis for a review, a consideration, and an adoption of the work of Trooper Paul.
I fully agree with what Bob Alessi is arguing here. And knowing that, how can you not let these defense lawyers ask the new accident reconstructionist about the old accident reconstructionist report using the same or similar data, some of which he used in his report, some of the pictures, the guy himself sitting in the car, Trooper Paul, is in the photos, and he lists all these different slides that Trooper Paul is on. So how would you not let the defense ask Dr. Welcher about that? Lisa Bishop said a more forceful Alessi was what I needed to see. So do you, as the chat, agree? Did you want him to be more forceful today? Did you like the change in Alessi today? I would completely agree that he was more forceful, more controlling. He put the witness where he needed to be If he was dancing, he brought it back in. So the way that his demeanor was today was definitely different. Do you think it was more effective? Because that's really what we're after as lawyers. We want to be the most effective advocates for our clients we possibly can be. We don't want to be bullies. We don't want to be big shots. We don't want to be bad guys or good guys or the Dark Knight. We want the best result for our clients and for justice. Okay, let's jump ahead a little bit into Alessi's argument, and then we'll hear Hank Brennan's response.
My point here, Your Honor, the Commonwealth is doing is this. The Commonwealth knows Trooper Paul and Dr. Scortibello are problematic for their theory and their narrative. Trooper Paul has got, if you work backwards from his key cycles, you end up with 1162.2, their key cycle. That ends up being not in front of 34 Fairview, but it ends up when the Lexus is in the possession of the state. That is the result of that. And that was something that was addressed square head on in the first proceeding. We're not coming up with some fanciful ghost in the second trial. This was gone through extensively in the first proceeding. And I understand this is a new trial, but it goes to show it's not something coming out of the blue, etc. And with regard to Dr. Scortibello, it was remarkable on the redirect that I've never seen a prosecution essentially go after the opinions and conclusion of their own medical examiner when they basically said, medical examiner, I can't call this a homicide. The manner of death is undetermined. And the medical examiner says, I don't see any motor vehicle impact injuries. There couldn't be anything more apt, more probative than whether or not the injuries to the decedent are from a motor vehicle. The Dr. Welcher himself is saying they are. That's the essence of his opinion. It's the essence of his test. We get to be able to respectfully, Your Honor, say, well, wait a minute. You said you looked at the autopsy. You said this. You highlight it, but you're going against the medical examiner on whether there's motor vehicle injuries. The experts can't, Your Honor, cherry pick and choose from documents. They can't use it as a shield and a sword. They can't put up, for example, Dr. Scortibello's autopsy report, cherry pick things to benefit from them, and then and they did it on direct. And then all of a sudden on cross, when we want to go and test that, they say, oh, no, you can't do it. Your Honor, this whole argument is absurd. And it's antithetical to the Sixth Amendment. And even if, and this is my last point, even if this were merely a civil case, this would be routine cross-examination against the expert on the side. So in conclusion, Your Honor, I respectfully request that Ms. Reed and her team be allowed to exercise their constitutional right to cross-examination, the keystone of a defense in a criminal trial.
I agree with him 100%. Here's what I will say. The only way I think the Commonwealth may have been able to protect against this is have Welcher look at nothing Trooper Paul touched or did, use nothing Trooper Paul did, if that was possible. I don't necessarily know it was possible. But because he did what he did with Trooper Paul's report and information and photographs, I just don't get it. I just don't understand how Judge Cannoni would not let them cross on Scortibello and Trooper Paul. Like, Welcher's supposed to be the guy. He looked at everything, right? And they used that to say, this is the guy with all the information, jury, you should listen to him. And when you present a witness like that, the defense should be able to cross-examine him on everything. That's how it should be. And then we get just a very typical argument from Hank Brennan. He argues hyperbole and, exacts, and he argues definitive statements, whether true or not, whether they're even on point or not. And he ignores all of the issues. He also loves to say things like, there's no case law. There's no rule on this. It's like, well, there's no case law that says when you try somebody twice and the first expert was so bad that they're not going to testify in the second trial and they hire a second expert and they look. But what you can do is whatever an expert looks at and relies on or uses, you can cross-examine them on that information. So, the Karen Reed case is a one of one. There's not going to be any perfectly on point case law, but for the principles and arguments made, there absolutely is, in my opinion. Absolutely.
There's no case law, as much as they urge the court and yell out the word case law and constitutional right and Sixth Amendment right. There is no case law.
As long as they yell out constitutional rights, like, I mean, whoa, we get it. You know, she's got a constitutional right. It's like, it's pretty important in these kinds of trials.
A lot of support what they are trying to do. It is a simple endeavor that is clouded by all the rhetoric that they offer. And it is clear, and the court knows what they're trying to do. They're trying to pit the inadmissible opinion of a non-testifying witness against a testifying witness. They have asked Dr. Scotty-Bello what her opinion is. And although it's not consistent with our reading of the case law, they were allowed to introduce that it was an undetermined cause of death or mechanism. That evidence is already in front of the jury, but they can't simply repeat it.
Notice how he asked that evidence, or how he said that evidence is already in front of the jury. And at the end of the day, that is why I think Judge Cannoni is going to be protected in this opinion, because I think the defense, whether they call Trooper Paul or not, I think his explanation, his report, what he says happened, they've already got a bunch of Commonwealth witnesses to confirm who Trooper Paul is. So the jury has already heard that name. So when and if ARCA gets up and says, here's what Trooper Paul did, here's what Trooper Paul said, here's why it's completely wrong, here's why it's different from what Dr. Welcher said, that evidence is going to come before the jury. And so maybe this will all be moot and it won't turn into a material problem necessitating an overturning of a verdict potentially in an appeal. So that's why. But again, I would still push against that the defense should be afforded the option to discredit this Commonwealth witness at this point in the trial, because it's very important right before the Commonwealth closes. Has a juror already made up their mind? We need to confront him with these now. It's not the same to have it come in through our paid experts, which is what the Commonwealth is going to push to the jury in the credibility. So it does matter. But will it be material enough for an overturning of a verdict? I would probably guess no.
It because it sounds good to them or they think it's helpful. Simply because a witness uses a document or looks at it or uses part of an autopsy does not let them regurgitate an opinion that's already in evidence to try to phantom cross-examine an expert. Dr. Welcher is clear. He did not rely on Dr. Scotty-Bello's conclusion that this cause of death was undetermined. In fact, as an aside, he said, I wouldn't, because she's not qualified for that. And so this is a simple game.
Medical doctor is not qualified to do her job, which is what she does every day.
Let's pit one witness against the other and suggest that the Commonwealth's witnesses are inconsistent. They take it as
well, that is in fact in the jury instructions, that a juror can find reasonable doubt in the conflicts in the evidence and conflicts in the testimony. So that's kind of defense lawyer's job if it exists. Some cases it doesn't exist, especially not to this level.
Step further. They want to relive what they think is their past success last year in this case without actually
what they consider their past success last year. They want to relive it. That's the argument he's making here.
Calling the witness. They want the jury to hear their perspective that a past witness had confusion in his analysis, but they don't want to call the witness. They want you to allow them to do that, not just shouting it out and have sustained objections, which has happened this entire case, but they actually want you to be able.
Again, I don't mind that argument, actually. I think that he's right. They just shout it out in questions, and they don't even care if, I object or it gets sustained, because that's happened throughout the whole case. Now, he's done it a bit too, but I'm fine with that argument. He's like, Judge, they've been trying to throw in admissible stuff in here the whole time. Let's nip it in the bud. And while I disagree with the end result of his argument, arguments like that, I think, can be effective if the other lawyers are pushing the boundaries a bit. He's dead wrong on this, what he's proposing here. But again, those types of arguments is what he's making. Some hit. When they miss, it's a huge swing and a miss, but I don't hear him making any legal arguments, really.
Be able to allow them to ask Dr. Welch these questions, which he did not rely on. We had a voir dire. He was clear. He did not rely on me.
You were clear, Brennan. You were clear on the questions, the answers you put into your questions. He was actually not clear. I did not find him to be very clear on whether or not he did or did not rely on this
analysis of Trooper Paul. He did not rely on that determination or undetermined determination by Dr. Scotty-Bello. It is that simple. They try to throw some fluff out and they throw around some documents. We have slide 22. Simply because there's a suggestion that Trooper Paul might be the hand in the picture is not an anchor. It's not a tether. It's not an adoption. It's no such thing. In fact, if you look at that photograph, it was taken by Zach Clark. So by the rationale of the defense, they should now be able to ask Dr. Welcher any question they want about Zach Clark's opinions.
Sure, that's a decent argument. If it was one picture on one slide that we were talking about, but it's not. It's so much more than that. It's multiple slides, multiple pictures. Even some of the data and explanation from Trooper Paul was taken into consideration, even if he disagreed with it, which Alessi makes that point. He's like, just to be able to ask an expert about information that they relied on doesn't mean they have to agree with it. If they disagree with it, you can still ask them about it. Why do you disagree? What did they do wrong? Because it's not usually both Commonwealth experts, right?
Efforts what Zach Clark did. It is a photograph that he considered, not an opinion, not an analysis. It has nothing whatsoever to do with Dr. Welcher's analysis or opinions. In fact, the evidence is to the contrary. He came out, conducted an independent analysis, did all of the work himself, considered documents, and he was specific about what was part of his opinion and what was not. And this information was not part of his opinion. They turned to the Google map. Bit misleading. This was generated by Google. Two separate people used the same program, but when you look at the CARS report and you look at Dr. Welcher's PowerPoint, it's different. Dr. Welcher's has a map on the side, and when you look at the numbers themselves, the CAR report says minimum 36.1, maximum 38.8. Dr. Welcher's slide, 37.9, 38.1. So in no way did he adopt, anchor, tether, use as any basis. In fact, his is different and separate, as all of his analysis is. And so the portrayal of this necessity of information so they can sneak in inadmissible opinions with no witness is simply improper. There is no case law. There is no legal support for it. They cannot reach back into last year and manipulate a witness and ask him about something that he didn't rely on because it feels good or it sounds good for their case.
By the way, just to clear it up, and again, obviously I'm wrong in Massachusetts because Judge Cannoni would rule against the argument I'm about to make. But in every trial I've done, anything that the expert has looked at, they don't have to rely on it. I mean, I guess rely on, if you reject it, if you include it, or if you don't include it in your analysis, usually there's a reason why. And I've even been able to ask experts why. Like if you're looking at these old medical records, why did you not consider these? Well, I didn't consider them to be relevant. Why not? Because it's a different part of the body, or because it's a different country, or because it's a different person, or whatever. Give me the reason why you didn't rely on that at the very least. And then I should be able to say, different part of the body, it's the shoulder, which can be confused with neck pain, or it's the neck, which can be confused, whatever. I should be able to ask and really dig in to see, are you right that it shouldn't be relevant? Are you correct in what you say is wrong or irrelevant, or why you didn't use this more from something that you did look at as you're doing all the analysis and looking through all the documents and information to come up with your opinion? Absolutely. And we're talking civil cases. You're allowed to do that.
Dr. Welcher did not rely on Trooper Paul's analysis or reports, and he did not rely on the conclusion of Dr. Scotibello of undetermined. If they want to call Trooper Paul, well, maybe they can try to do that, but Dr. Welcher is not the right witness for it. These opinions to try to do a credibility eval is a core preclusion in criminal law, a core preclusion. You cannot vouch for the credibility of another witness. You cannot comment. It's like asking to the police.
Literally not what they're asking. And Alessi comes up with his next argument and says that. It's like, Judge, we are not asking, this is not a credibility battle. This is not a credibility battle.
Police officer lied when he said the light was red. It's the absolute.
Did a police officer lie when he said the light is red? Obviously, you can't ask that. That's not the same thing we're doing here.
Same analysis. It just has a lot of icing on it.
Your Honor.
So I'm going to skip Alessi's argument here. He basically said he ignored 90% of what I said. And you guys, the Commonwealth, brought Trooper Paul and his information and his analysis. And look at this freeze frame. It looks like he's got somebody by the you-know-whats. But he basically is saying, the Commonwealth brought Trooper Paul into this. You brought his analysis into this. You brought what he thought into this. Let me answer some questions before we get to the judge's ruling. Would you address Signal with ARCA before the Commonwealth does? So with some younger jurors, I don't know how Signal's going to play, right? Do they think Signal's no big deal? Do they think they should? Do they not trust the government? Do they think that's exactly how we should do it? People are getting screwed, whatever. I don't know how I would deal with it because I've never had to deal with it. I would say we talk through different forms of communication. Signal, why do you like to use Signal? I assume they have an answer for that. Because it's encrypted and nobody can get their hands on it. And we work with the federal. I mean, I may, if I'm ARCA, say we work with the federal government a lot. They like us to use Signal. I don't know. Is that a thing? I don't know. Right? I'd have to have more details on it with how I deal with it. When Welcher comes back, does Alessi have to be the one to question him? Do you think he's the best one to do so? I would not say switching lawyers would have made this any better. I have a lot of thoughts on how cross went today, so I'm going to save some of them. Yes, you can't switch lawyers in the middle of cross-examination, at least in every jurisdiction I've ever practiced in. Jessica, Peter, did you see the motion to call Proctor's friends to authenticate the text messages? Is this better than actually calling Proctor to testify? I saw the motion. I don't necessarily know that we know that that's for sure that it's going to be in lieu of or instead of Proctor, but it may just be another way to get these text messages in if they don't want to call Proctor. I get that Brennan will be able to cross Proctor. I get people saying that he might be baiting the defense and calling him. I do not know how Proctor is good for the Commonwealth, but Michelle, in his rebuttal case, whom is Brennan limited to calling? Can he call Flamati? Can the defense call Arca again on Sir rebuttal since JW is allowed? I think they should absolutely be able to have Sir rebuttal on at least Welcher, because Welcher is going to be able to come and bring in new information that he did not testify to, that he would have been able to and should have been able to testify to during their case in chief. So on that limited information, they should be able to have a Sir rebuttal. Will she let them? I don't know. On the rebuttal case, I can't answer that yet because we have to see what comes out in the defense's case in chief. If they hammer Flamati, or if they hammer the I did it or I hit him or whatever, and they say that Flamati's going to come and respond to that and say she actually did say it or didn't say it or whatever, then yes, potentially the Commonwealth will be able to bring him, but it has to be in response to what the defense brings up in their case in chief. Okay, Peter, if you're betting, who does the defense call first? Who would you put up? I don't know. Again, when I do this, I agonize over it. I think about it so much. I want to call the correct order of proof. I can see, some odds being on Arca first, right in response of Welcher. But I can also see starting out with some smaller, simpler witnesses. I can see starting out with, if you want to call the Proctor Higgins gang, I don't really know if I would start out with that. I'd really have to think about it. I have to go back and kind of see, maybe you start out with the ME, kind of simple testimony. It's a Friday before a weekend. Do you want to split up Arca? There are so many things I would take into account, and you would watch my beautiful mind type of work going back and forth, second guessing myself 100 times. I'd really have to put more thought into it. But I think Arca is up there. I just am not sure logistically if that's going to work. Peter, for M2, given though they won't find intent for it, is the bar for reckless to meet M2 standard like super, super high? Yes. I don't think that is going to be a second degree conviction here. If there is a conviction, I think it will be on count 2 or some lesser included. Christy, do you find it normal and or frustrating the way the judge rushes the defense in the key arguments and questioning? I got to be honest, she's not the only judge to do that. She's not the only judge to rush a lawyer. And we've actually seen in other cases where there's literally a timer. It's like, this is what you have left. Do what you want with it. Brantley, and I also think the defense attorneys have pushed back at certain moments, and they should if they feel it's necessary. Seems like a bad witness to end for the closing of the case, and Chief Analessi ending on him, not accounting for ride height. Big questions left. I don't think he was a horrible witness for the Commonwealth. I don't think he was an A+ witness. I think he was fine. I don't think it's the worst witness to end on. I understand. I may have ended on the same witness as well. So I don't think it was a swing and a miss for them to end on him. And frankly, they ended on something better than him, which we'll get to. Nika, did you see the Commonwealth's motion to exclude Arca new opinions for Rule 14 violation? And what do you think Bev will do? I think she's already decided this. I think she's going to let it in, and she's already cured it by letting Welcher come back and talk about any new opinions they have. J-Mac, is it normal for the prosecution to change their story detail about what happened multiple times during trial? I don't know if I would say it's common or normal, but it's absolutely happened. It's happened to us, and we've had to deal with it. It's very frustrating, very annoying, but it does happen. Brian B., why are you allowed to go to trial with things that didn't go to the grand jury? Following since wholesome podcast, Chauvinger on GMA. Yes, happens in every case, because you need a lot less for reasonable or for a probable cause for a grand jury to indict somebody versus beyond a reasonable doubt. In every case, there's more information that comes into the trial, and sometimes even different information. Do you think the defense should consider calling Trooper Paul in light of Judge Cannoni's ruling? I think they should be able to get it out with Arca. Did you review this opinion? Who is Trooper Paul? What did he say? Why is it wrong? I think they should absolutely be able to review and talk about that because it's in the records that they reviewed and it's part of their testimony. All right. So now let's get back into, or actually, first we're going to hear Judge Cannoni's ruling.
I'm not allowing in the, so I disagree with you, Mr. Alessi. I'm not allowing in the line of questioning regarding Trooper Paul, and I'm not allowing the line of questioning regarding Dr. Scordi Bello. So That's my ruling. Let's bring the jury in.
Shocker. She's not allowing it in. She disagrees with Mr. Alessi, and therefore he cannot ask those questions. So that's going to abbreviate his cross, number one, okay? Because it finished much quicker than I thought today, right? He thought he might be going into Friday, and he finished very early today. So that's one reason it's limited. But also, when we talk about the difference in not just Alessi's demeanor, but maybe his strategy today, and I wanted to bring up this question, Coop. I hate to throw shade at Alessi, but crazy no taillight questions feel like the gunning tire slippage could be from stuck in the snow, and Karen Reed's weight, even though she's tiny, plus cargo would affect the vehicle height. So this question and a lot of things that people are thinking Alessi did not get into. I actually think it was a better strategy today than yesterday to keep it shorter, try to get in and get out. We'll talk about whether or not he really landed any punches today, but it was very clear from yesterday. It was not going to be smooth. It was not going to be easy. You weren't going to get all the points you want to get out with this guy. So why not save these questions for your experts? He was never going to give him great answers to taillight questions, in my opinion. I think Alessi figured that out and was like, why bang my head against the wall? Why potentially make jurors hate me? Why bore them? Why confuse them? Let me get in what I want to, and I'll get the big stuff with my own experts. I could be wrong, but that's the way I look at it. So let me also mention off the top, before we get to the continued cross-examination, you guys, the chat, there are people from both teams, but especially the defense, in my opinion, watching social media, YouTube channels, Twitter, whatever, TikTok, and they are picking up what you are putting down. Multiple times you've said something, and I'm like, I don't know. If it's important, I assume the defense is going to bring it up. And I wanted to highlight, and kudos to you guys for bringing up stuff that the defense actually absolutely mentioned today. Number one, in the very beginning of cross, Alessi says, hey, can we make sure Dr. Welcher is not only not looking at his laptop, but also not looking at his watch where text messages and emails can come through. And it seemed like Welcher was a little offended by that, but the judge is like, yeah, don't look at your watch. And I saw that all over Twitter, and I saw it during my chat in the video yesterday. Additionally, we've heard Alessi ask about the difference in height for the burn. Well, today, as Josh H. is pointing out, they had a lot of discussion about the difference in the height of the Lexus, hydraulics, suspension. Welcher testified today that he relied on the vehicle suspension height from 2.1. Well, that was part of Trooper Paul's report. There's no doubt in my mind he relied on and reviewed and considered tons of what Trooper Paul did and should have been able to ask about it. But specifically the ride height and the hydraulics and the up and down of the Lexus, whether it's parked, backwards, forwards, fast, slow. We'll talk about what Judson Welcher said about it, but you all were bringing it up yesterday. And maybe Alessi had it in his cross. Maybe he picked up on it from social media. I find that to be very interesting. I'm speaking to the Florida Association of Criminal Defense Lawyers literally 1 week from Saturday. And we will be discussing just this, what you guys, the chat, have done to the criminal justice and civil justice system, how you all are affecting it as the public, as society, watching and following these cases. I'm fascinated by it, frankly. So they start talking about the glass on the bumper. No evidence it matches the glass. The cocktail glass, very confusing. Welcher's arguing with him, saying, well, there's no really proof of that. They didn't try to put the glass back together. I thought that was just a bad argument by Welcher. I think it's been pretty much confirmed. It does not match. And to argue that makes it look like you're really trying to nitpick, in my opinion. But Alessi keeps trying to get him to agree, and Welcher won't agree, and they kind of go back and forth. Then they talk about, will that affect your analysis? He kind of says, no, it doesn't really matter. He's like, well, they did test it. Did you not read all the reports? And he's like, well, I thought I did, but apparently not. It's a small victory for Alessi there. Then they start comparing the testing they did at Meadows versus Fairview, and they really talk about the ring camera. And I said that I thought the testing that Welcher showed about the Lexus and the Traverse at One Meadows was the type of testing I expect from a witness like this, an expert like this. And how I thought it was just vastly different from the pedestrian accident testing, which was much less precise and much less convincing. But as Alessi picked this apart with the different angles of the ring camera and the different manipulation and different types of ring cameras, and that's a different ring camera than it was before, and how Welcher didn't seem to care about the different models, the different angles. He's like, oh yeah, we took all that into account. We would have been notified if the error was too large. Alessi created real doubt for me about how and where those vehicles collided. But Welcher did agree they did collide to a low impact that wouldn't have caused a break in the taillight, he said. But I thought Alessi did a great job creating doubt as to the accuracy, because we all know how different a different camera angle can make things look. And frankly, the Commonwealth's own witnesses have argued with Alessi about that exact point. We talked about 3D photos and are photos photoshopped, and is this really 3D? And there's reports inside the courtroom that witnesses were side-eyeing or shaking their head when Welcher was saying that's a 3D image. I don't know. Feels a little bit like foundation being laid to their witnesses, which again, I think was an altered strategy from Alessi yesterday, trying to make Welcher his witness, which I really did not think went well. Today, it was shorter, simpler. Let me get a couple points. Let me lay some foundation. I'm going to toss up the ball and hit the home run with my witness. And it was a shorter cross. It wasn't an overly effective cross. It wasn't a home run type of cross, but it's what you can expect with good experts, effective experts, difficult witnesses sometimes. They are just not going to let you turn them into your witness. Let's listen to a little bit of this battle, though, because Alessi was much more forceful and battled a lot more with Welcher today. Again, not what I was hoping for personally. You can tell me if you think, a lot of you said you thought it was more effective. There were parts where I was like, a little bit of a cringe maybe from the jury, but we'll see if it ends up being. I don't think this witness is going to win or lose the day for the defense, because they still have their experts to call. But let's listen to a little bit of this exchange.
There's a photo we could show, or a scan that is on the rear of the vehicle, and it contacts on the corner, which is just around, so maybe like an inch or so in front of it on the corner.
I'm just going with what you presented in your slide.
Well, let's go to the next slides, and then
sir,
maybe
I will determine which slides we go to on my questioning.
I'm just hoping
so
to
now
answer your
let's
question.
go to Mr.
He's like, go to the next slide. He's like, sir, I will determine what. This is my questioning. This is my cross-examination, Alessi says, definitely pushing back. JW said he did not show ruling out null hypothesis. That's kind of my main issue with Welcher, just generally speaking. If we look at a higher level view of his testimony, it's like, okay, you showed how it could hit the arm. Are there not 100 possibilities that are equally as likely as the one you decided to show a demonstration of to this jury? Flav, how long have you had a YouTube channel? Since the end of 2020, about 4.5 years, which is wild to say. And if all you guys subscribe during this video, we will hit 500,000 subscribers before the end of the weekend. That would be awesome. Can the defense play Karen Reed clips? Why or why not? Only to put into context what the Commonwealth played. They cannot just play self-serving hearsay. That's the difference between a party opponent, and the defense knew this when she did those interviews. BB, Peter, I logged in late, so you may have already answered. Why did Brendan say the defense can try to call Trooper Paul? He said they can call him, but I don't think he thinks they're going to. So he's like, they can't not call him and try to get into his opinion. They didn't say they can try to call him as if they can't. They can absolutely call him.
Mr. Wolf, the next slide.
There we go.
In your presentation, my question is zeroing in.
Welcher's like, there we go. Like, thank you for doing what I asked for.
Are you saying that that slide does not show contact between the tail light of Ms. Reed's Lexus and any part of the Chevy Traverse?
Yeah, absolutely. It's exactly what it shows. You can see a little.
This right here is a picture that shows camera angles, inches. All of that is incredibly important. And so if there was a big difference in the camera, the angle, or even any difference, even a small difference, can make a huge difference in his testimony, in these pictures, in the point of contact, and in the potential damage done to the Lexus.
A little better here. Again, we tried all these different angles, which is why all these slides are in there. But you can see some of the geometry of the light, this structure. And again, remember I said the Chevy kind of curves in as it goes up a little bit.
Let's go to the next slide. 40, yes, please.
So I don't, again, if it were me, I would not call Trooper Proctor, in my case, the chief as the defense. I would just use what he said and his name with ARCA, the defense experts.
The quarter panel taillight in each, do you see a jutting out of the quarter panel taillight in that photo? Do you see it jut out?
So I don't know if you and I are talking the same thing. There are little fins here.
Correct.
I'm going to jump ahead. This is not, we're going to get to, again, some more of the battle back and forth between them. Sarah, I am too. I don't know why they didn't x-ray it with all the injuries there. It's not like they needed to x-ray, his lower extremities, which had like no injuries to them. So I understand why they didn't x-ray them. And that's exactly the argument I would have made. No visible or any injuries at all that you could tell from the lower body. That's why they didn't x-ray them. But I don't know why they didn't x-ray the arm. I keep pointing to the other arm. Michelle, the fact that boomers don't understand newer messaging apps isn't the flex Brennan thinks it is, especially if the jury is younger. Yeah, we'll see.
You could have easily solved what you consider to be the issues you had with trying to show it lining up. Couldn't you, sir? You had an easy solution for that.
I took the best solution. I'm not sure what
You
you're
had
referring to.
3D images, correct?
I did.
You could have shown and measured 3D images to get almost the exact contact point and almost the exact dimensions if you had just used the 3D images that you had available to you. Isn't that correct?
That's exactly what we did. When I went through the video analysis, I showed you how we overlaid the point clouds, the 3D scans on top of each vehicle. So we took the, we took
Sir,
the vehicles.
please don't interrupt.
Hold on.
Your
Hold
Honor,
on.
he keeps referencing my hand and saying I'm doing something when I'm not. And I think that's distracting to the jury. I'm not.
So obviously Alessi's annoyed. We're going to back up and hear this again. So I think what's happening is Welcher is trying to make it seem to the jury like Alessi is trying to cut him off with some hand motion. Obviously, we can't see Alessi here. And Alessi's like, just because I put my hand up or just because I move my hand doesn't mean I'm referencing something to you. So please stop making it look like I am trying to shut you up in front of this jury. It's distracting the jury. Problem is the tone in which Alessi does it makes me cringe a little bit. And I'm just like, oh man, it makes me think you're letting this witness know he's getting under your skin a little bit, right? That's a little of the feeling I'm getting and the jury. Now, if the jury likes Alessi, they're going to be like, yeah, what a jerk. So maybe it's working with some jurors. I don't know. But that was the point where I was just like, I don't know if this controlling and kind of overpowering version, to me, it was like, it was tough because again, I liked more of the strategy today, get your points and move on. But this was one where in front of the jury, even the judge's face was a little bit like, but she didn't reprimand Mr. Alessi because I think she probably understands how frustrating this witness is. We'll listen to it one more time.
Through the video analysis, I showed you how we overlaid the point clouds, the 3D scans on top of each vehicle. So we took the, we took
Sir,
the vehicles.
please don't interrupt.
Hold on.
Your
Hold
Honor,
on.
he keeps referencing my hand and saying I'm doing something when I'm not. And I think that's distracting to the jury.
So,
I'm not interrupting him.
Hold on. Let the witness answer the
I
question.
am. I'm just holding my hand like this, Your Honor. He keeps saying that I'm doing
Mr.
something.
Alessi, please.
All right.
Go ahead, finish the answer, Dr. Welch.
Again, in the photogrammetric analysis, I showed the video. I showed how we overlaid the point cloud on top of the video. That proves that the way we solved it, correct camera characteristics, matches. Otherwise, that would be distorted. We overlaid the scans of the Lexus into the photogrammetric analysis. We overlaid the scans of the scene into the photogrammetric analysis. We overlaid all that stuff into the analysis. We did exactly what you're suggesting.
You could have easily addressed this issue by the following. If you really believe there was no contact or not sufficient contact, you could have produced a graphic that shows a gap between the two vehicles. A graphic, couldn't you? That's not a graphic.
What is that?
Sir, I get to ask the questions and you are to answer them subject to the judge's ruling. So my question is, couldn't you?
Again, it's like, I get it. I understand it. It's just in the flow of the cross. These were some of the tougher parts. Alessi had to be careful. JW being difficult, trying to control the narrative, and Anti-Bev allowing him and mind-boggling. Am I wrong? I don't think Judge Cannoni was allowing him. I feel like Judge Cannoni, when Alessi would tell her he has got a problem, was try to fix it. Same thing with like the watch, things like that. Tom, I'm surprised the judge can make a ruling and give no reason other than they disagree. Is that normal? She gave somewhat of a ruling. it's not a written order. I don't know if she's going to reduce it to writing. Sometimes if they reduce to writing, but yes, they're allowed to and kind of adopt the winning lawyer's argument or just say they disagree with their argument. It all depends on what it is as well. Certain things certain orders judges do have to make findings in different jurisdictions. But it is wild sometimes. And it's very frustrating because it makes it impossible for us to appeal certain rulings. Happens to us too.
You have created a graphic that would have better shown the issue that you are creating or talking about today. That's my question. Couldn't you have created a graphic?
We did. We created a whole bunch of graphics.
You called what we just saw a graphic?
Yes.
Well, if there's a gap, why isn't there then something that shows a clear gap?
Because when you have the angulation of the vehicles, you have perspective. When you're looking at it, even if you do it top down, you see everything projected onto a single flat plane. So you can't tell the height of things. So when you see things in this dimension, you can't necessarily see depth of things. So you lose in 2 dimensions.
I did not think this was a great argument by Welcher, and I thought Alessi actually made his point after all of that. And Lotz's mom, probably not going to be admissible. That might be one of the reasons why. Maybe it's not as exact. Usually the way they do it is with 3D models, kind of like how he did it, but the ones that I've seen are a little clearer. Then Alessi, again, an argument I didn't really agree with that Alessi was kind of making through cross is, you're not the one that did this. You're not the one that did this. You know, one of his employees or somebody else at Aperture actually punched in the keystrokes. That happens with every expert like this. Every engineer I've ever hired has other people. Sometimes they have other people go out and measure, put it in, photograph, whatever, and they're still allowed to testify to it. So me personally, that wasn't a big deal, but maybe to a lay juror, they're like, wait, you didn't even do the work here. And then we get to the height tolerance, which I personally thought was a great argument by Alessi. Let me see if, I don't know if I have that full stamp here.
I have that documentation. I don't know off the top of my head.
You have
There's 18.
18. Stay on the events, okay? Only one of all of those events, those 18, are you concluding that there was a collision associated with them, correct? Just one.
No, all those 18 are before.
This is after.
Database that you say the stated purpose is to assist technicians at Lexus.
I don't have the stamp. I don't know what happened to it, but basically the height tolerance on the Lexus is 5 inches. It can raise up 3 inches and lower 2 inches. How did that come into your analysis? And he's basically like, I don't really care about that. That I thought was crazy. And again, I'm wondering what foundation is being laid with the height analysis that ARCA is going to be able to blow out of the water with. How important is that? If the car is off when you do your measurements, is it lower than when it's on? When it's going backwards at 20 miles an hour versus going forwards, what height is the car at? Because 1 inch can make a difference, let alone 5, right? If the car is 5 inches higher, the blue paint's hitting him in the face. If it's 5 inches lower, it's hitting him in the butt. Like that's a big deal to me. And I thought that was potentially the best point of this entire cross by Alessi. You get what you came here to get on cross and you move on, which I thought Alessi did a very good job at that. No collisions. We'll listen to a little bit of that as Alessi's kind of talking about how, oh, well, we know there was a collision at Wood Meadows and it didn't pick it up. I didn't think that was this is what he ends on. We already knew it didn't pick up that collision. We knew it didn't pick up the collision with John O'Keefe. Nobody is saying it picks up every minor collision because they are too minor. So to me, this wasn't a super strong point. I would have loved an ending on the 5-inch height variance, but that's just me. You guys let me know what you thought. This is kind of the final point Alessi makes on cross.
Mileage away from everything.
But you're not concluding, even though they were so far away and you didn't look at them, you don't conclude from the information you have that any of them were a collision, correct?
Okay. Sustained.
Let's go to 5:07 a.m. on January 29th, 2022 at One Meadows, the home of Mr. O'Keefe.
Okay.
There was a collision between Ms. Reed's 6,000-pound Lexus and Mr. O'Keefe's approximately 4,500 Chevy Traverse. That's undisputed, correct? They collided. They made contact.
They touched.
Right. But the actual collision at One Meadows did not register the recording of an event on the Lexus VCH system, did it?
Correct. Too minor.
So, however, you want this jury, sir, to conclude that the glancing blow that you contend occurred at 34 Fairview Road by the same 6,000-pound Lexus in contact with a mere 216-pound man did register an event on the Lexus, correct?
No, the impact didn't register the event. As I pointed out, the trigger.
It is true. Like, I do think that's kind of been their testimony the whole time, is that this impact with John O'Keefe, if it happened, did not register an event. And I actually think that's better evidence for the defense. As Linda Kay said, if it was a hard enough impact at 25 miles an hour to shatter that light, I would expect that it registered something.
The trigger was from when the accelerator pedal went to 30%. The tech stream does not register crashes at all. It registers excessive acceleration, excessive steering, excessive braking, things like that, things that would be part of the maintenance system. So the tech stream.
So it doesn't register any collisions, airbags being deployed, nothing like that is registered. That's interesting. We'll see if ARCA agrees.
Will never register an event, even if you hit a wall at 100 miles an hour necessarily. It'll cause fault codes and things like that. But that's not what it does. The trigger here was transitioning
Other codes, he said, that are tripped.
into reverse and then gunning the accelerator pedal in reverse. And so when it went from 30 up to 74% throttle, once it went over 30 in that transition, that's what triggered the tech stream. It had nothing to do with, and that's why I'm telling you, I don't know when in that event the impact occurred, because the tech stream doesn't tell you that.
Thank you. That
You're
is
welcome.
exactly my point. The tech stream information doesn't tell you when a collision occurs, does it?
Correct.
That's all the questions I have at this time, Your Honor.
All right, why don't we take our morning recess?
All right. That was the end of cross. And I think it ended because a lot of people, and part of this is the defense's own fault. They've had so many good cross examinations, so many good questions, so many aha moments. Alessi's had Matlock moments himself that they expect a lot in some of these cross examinations, which is why I just think kill them with kindness, make sure the jury still likes you, respects you, trusts you at the end of it. You just get the points you need with certain, like Dr. Isaac Wolf, right? The Commonwealth's brain surgeon. You just get in, you get out, you get the points you need, and you move on. I think that potentially would have been more effective with Welcher. I don't necessarily think Jackson would have been more effective. I think it would have been even more of a battle. Maybe even Yannetti would have been the best. I don't know. But I definitely think Alessi is their expert lawyer who's going to do the battle of brains with these experts. So I don't think they're second guessing that at all. I actually thought day 2 was more pointed and was just kind of like, just a normal cross. You get in, you get out, you move on, not some, riveting moment necessarily. Before we get to Hank Brennan's redirect, let me answer some questions. Go Blue. Is ARCA changing their slides like the Commonwealth did in the middle? I don't know. Only time will tell. I guarantee the Commonwealth will be mad about it. But we know she's going to let Brennan call Russell regarding the lack of dog DNA, teeth molds. Isn't that the same concept? Oh, I get what you're saying. If Russell looked at the report and said the report was wrong, I don't know about the teeth molds. I thought she said that wasn't coming in. But he is going to be able to ask Russell about his expert opinion. And the defense is allowed to ask Welcher about ARCA's opinions. Maybe he'll have to do that on their rebuttal case, but he will be able to ask that. What he's saying is a non-testifying witness like Trooper Paul. So there is a difference there. Somebody from Beverly Hills, California is calling me. I don't know who that could be. Project Calm. Signal is simple to explain. The state opened the door. Her cell phone was gone through at night without a taint team while looking for news. That's a good point. It's a good point. Maybe you want to say, hey, we knew the cops were shady in this case. That's why we did it. And C, you notice the Commonwealth appeal attorney is in court daily. Why? That's not unusual. I don't know which one is their appellate attorney, but that wouldn't surprise me if both sides had that. Falvo. Sorry if I missed it. If they added the taillight to the images, doesn't that make it photoshopped? I mean, if they're creating fake cars, right, and putting it on there, I don't think that makes it photoshopped. I think that's them 3D image creating. There's a difference between photoshopping and editing it. I think, again, I'm not an expert. I'm not even going to try to opine on this, but we'll see what the defense ends up coming up with their testimony. You have said whoever calls a witness should be the last person to address them. Was it odd Alessi was the last person to speak to Welcher? So this judge has allowed that a couple times. If I was Brennan and I had more to say, I'd say, Judge, I get my last bite. It's my witness, but it doesn't seem like he wanted to necessarily. Can you plead the fifth to things you testified to in a previous trial, Proctor? No, not usually, because it's already out there. And you're not under criminal investigation based on what was said in those proceedings. Maybe if they took that and they were prosecuting you on what you said before, then yes, you could plead the fifth, even though you've testified to it in the past. That's not the situation we have here. Did you see the DOJ arrested a sheriff deputy yesterday? Does that prove they are still investigating the Norfolk police? Yes, I saw that. No, it doesn't necessarily prove that. Can ARCA change a slideshow like Welcher? I mean, the judge would have to allow it, depending on the materiality, right? Is it reversible error in opinion, or there are specific situations, and what does it mean? Yes, it has to be material. It has to be a big enough problem as to not give Karen Reed a fair trial, as to potentially change the mind of the jury, as to step on her constitutional rights, her right of confrontation, her right to cross-examine these witnesses. So yes, it can rise to that level, but it has to be something that's very material and important. Hold on, I want to save that. Don't the tail lamp pieces show where the alleged collision occurred? By the way, how did they end up 7 to 10 feet to the side? Explain the physics, Doc. They just stayed away from all the problems. And his answer was like, we don't have enough information to test that. It's like, well, smash a taillight up a couple of times and tell me where the pieces land. Just like you did with the arm. 1 out of every 5 times we smashed it, they end up 10 pieces. And the car had to be going 20 miles an hour for us to get that result. You can absolutely test things like this if you want to, if it helps your case. As a 17-year-old police officer, how can he reconstruct an accident scene and how a person was hit if he doesn't know how or where he was? You can create different possibilities. How fast would the car have to be going to throw a body 10 feet? Is it possible to hit the arm and throw a body 1 foot, 10 feet, 5 feet? Is it possible for him to get hit on the side and land on the back of his head versus the front of his head or the side of his head? You can do all those different tests to determine how the different ways somebody can fall, where they can fall, how you shatter the taillight and not break the arm, how you shatter a taillight where the taillight pieces go one way and the body goes another, or the taillight pieces in the body go to the same exact spot. And shatter a taillight, is it possible that somebody continues to hold on to that glass? What happens to somebody's phone in that scenario? I think those should all be fair questions for this witness personally. All right, let's listen to Hank Brennan's redirect.
To do, you literally press a button and stand there and watch it, and the laser does its thing. So I have absolutely no reason to disbelieve it. Additionally, again, if it was messed up, once you laid it over on top of the photograph, it would show the difference. So no, the data's fine.
Is there any evidence whatsoever that you've seen that any parts of your presentation were photoshopped?
No.
Any evidence that you've seen that your own presentation is photoshopped? It's like, hey, did you rig any of this? Did you alter any of this? What do you think he's going to say? Ooh, 496 subs now, Azam. So everybody hit that sub button. We're so close. It's crazy. Everybody hit the like button as well. We're coming up on an hour here. We don't have a ton of time left, but we are going to get through the end of the day and potentially the most important evidence for the Commonwealth.
You would ask questions about the suspension of the motor vehicle of the defendant's Lexus. Do you have any information that the suspension at any point was changed?
No.
Yesterday, you were asked a number of questions about formulas.
No evidence the suspension was changed, but he didn't do any of his work with the different heights to tell us how that would matter if it was changed. And did he drive the Lexus backwards and measure what the height was versus when it's off? So it's like he doesn't have that information because he didn't do the work.
You took out your calculator and you were asked about different variables. Were those variables hypotheticals or were they related to this specific case?
So they seemed hypothetical. Again, you have to be careful when you're talking about failure forces on biomechanical things. For example, if you impact the hand with a, say, 1-inch narrow metal bar, that's a lot different than if you have a broad, say, plastic taillight or rear body panel. So when you have distributed loads, you can take much more. I told you guys about sitting on the bed, like how much you sink in. That's an example of spreading your load out.
Wouldn't each individual jagged piece of taillight cutting into John O'Keefe's arm be more like the pencil applying force than laying your load out on the bed? right? Wouldn't each of those individuals, wouldn't that be the force? And it would take less force to make those, I don't know. My brain is twisted with how he's trying to explain all this.
When you spread the load out, you don't sink in as much. So same thing with, forces on your body. If you take this pencil, I don't have to press very hard for it to pull in. But if I spread it out, I have to press much harder. So you have to look at the distribution of the load when you're talking about the failure. So when you look at the failure loads, it depends on what you're doing it with. If I hit you with a 5-pound 2x4 or a 5-pound pillow, they're both 5 pounds, but you'd much rather get hit by the pillow than the 2x4.
When you were asked questions about communications, when you would have communications with the Norfolk County District Attorney's Office, did you ever use encrypted apps to secretly hide your communications? Apps like Signal?
No, I don't have any of those.
Here's what people were talking about before. Personally, I don't think he should be able to comment on that, because it's like, do you use Gmail? Why do you use Gmail? Oh, you use Gmail. It's just kind of weird to ask. I've never seen a lawyer ask an expert something quite like this. Now, in fairness, I've never had this specific issue come up before. But we also have to remember, when we're talking about Trooper Paul and we're talking about pirouettes and we're talking about shattering taillights and things like that, you have to understand you're bringing knowledge into this case that you probably had from another case. Not everybody in here, but a lot of people are bringing knowledge from trial number one, from arguments we've seen outside the presence of the jury. And you have to understand this jury is not seeing all of that. So I think he has created some reasonable possibilities of what happened. Will that be enough to prove the case beyond a reasonable doubt? We'll have to find out.
So the form of the question, ask it differently.
When you were communicating with members of the Norfolk County District Attorney's Office, did you ever use encrypted apps like Signal to communicate?
I'm going to allow it.
No, I don't even know what that is.
And that's actually a really great point by Alessi. She should absolutely sustain his objection, even if she thinks it's admissible, because it is absolutely outside the scope of cross-examination. Additionally, this is something he should bring up in rebuttal. So, and if he tries to bring it up again, the defense better object to cumulative. Anything he has said here, he should not be able to testify to again.
Would you ever use an encrypted app so those communications couldn't be tracked?
No.
Would you ever have any reason as a professional for doing that?
Sustain.
Now, unless he didn't need to get into the weeds, he probably didn't. But if I wanted to be a nitpicking jerk, I would say, are your telephone conversations recorded? Why don't you record all your telephone conversations? Why don't you record all those and turn them over to me every time you talk to Hank Brennan? Because you talked to him here. You talked to Tully on the way to the airport. You had 5 meetings with him in the last whatever weeks. You changed your thing mid-trial, right? You didn't record those conversations and send them to me, did you? I may have gotten up and done that on recross, honestly, because of how annoying this Signal conversation is and outside the scope of cross.
You were asked about confirmation bias. You remember those questions?
I do.
Could I have slide 33 of your PowerPoint, please? Slide 33.
Give me a second.
Madison said, if I'm a juror and it took the defense calling Proctor to get those messages in, I'd be pissed at the Commonwealth. I agree. And that's why I would call Proctor if I was the defense. I would not be scared of Proctor. Now, I've already made it known. I think there could be issues with McCabe's, Alberts, Higgins, calling those people. I could see how there would be issues. I don't see issues with calling Proctor personally, but they know more than I do. They know more than all of us about this case, no doubt about it, by a million. So I would trust their judgment on it.
You could zoom that in, please. A little larger so we can see it.
I cannot do it with one monitor.
You can't do it any closer than that?
Not since I took down. Oh, hold on. Here we go. Which part do you want me to zoom in?
Ms. Gill,
The simple answer is because the judge allowed it. Kim asked, why was Hank Brennan allowed to ask about Signal when it wasn't on cross? The judge allowed it.
can zoom in for you.
Sorry? Which part?
Ms. Gilman's going to do it for you.
Oh, there you go. Perfect.
If you could zoom in, please. Okay. On shift position signal, going forward, then neutral and reverse, does that data suffer from confirmation bias?
No, that's strictly electronic data.
When we look over at the vehicle speed, can we go to the left a little bit?
This was such a dumb line of questioning. It's like, well, is this number here in the spreadsheet biased? Is that confirmation bias? It's like, it's a number, sir. So no, the number's not biased. Now, what I did with it and what I said it means and what I said it proves and how I use it in my analysis could be biased. It's not, I would say, obviously it was myself, but it could be. Mariah said, is Brendan allowed to ask Arca in front of the jury about the text app? Yes, and I think he will. I think the judge is going to let him. And Bettero and I were talking about this on one of our videos. He thinks Brendan's going to be way nicer to Arca, not as, belligerent and angry and like fist pounding. I kind of think he is going to be just appalled and upset about everything with Arca, and he's really going to use all this foundation he's laid with other witnesses. And I think it's going to be more similar to his cross of Arca during the voir dire than Bettero does. So we'll see who ends up being right about that. I think it would be smarter to go Bettero's route if I'm Hank Brennan. But it feels like Hank Brennan can't help himself with some of this stuff.
Down. Vehicle speed ending at 2361 miles per hour. Does that suffer from confirmation bias?
No, again, these are direct readings from the vehicle. Again, that speed on this here, you have to correct for the slippage, which I do later on the slide, but that is a direct reading from what the speedometer is seeing.
Acceleration at the end of that 10-second window, 74%. Does that suffer from confirmation bias?
No, that's a direct reading of a sensor. That's objective information.
I have no further questions. Thank you.
Wow. Anything, Mr. Lessie?
And Alessi has a short recross here that we're going to watch.
Yeah, Your Honor.
Yes.
Thank you. Dr. Welcher, you were just asked questions about slide 33, which is a slide about text stream data. You acknowledge that text stream data, what you've called a trigger, like was on that slide, does not tell you if a collision even occurred, correct?
Correct.
With regard to the topic of confirmation bias that you were just asked about in slide 33, am I correct that all of the questions that Attorney Brennan just asked you were about data on that slide, correct? All that's on that slide is data, correct?
Now, he asked me more questions than just the slide.
But were the questions...
I didn't even answer that. The answer is clearly yes. Clearly yes. Now, is the jury picking up on that? I've gotten to watch this 2 times. Now I'm pausing it, commenting on it. I'll keep rehashing that because this is a very different way. There's a bunch of people that have been jurors before in our chat. A lot of you reach out to me. I appreciate it. I love when you share your juror insights with me because it just helps me learn. This experience, what we're doing on YouTube right now, is very different than what the jurors are experiencing inside this courtroom during this trial.
Questions just about data.
On this slide, it was just about data.
Correct. But confirmation bias is really aimed at opinions and conclusions and alternative hypotheses. Isn't that what confirmation bias gets at?
So generally, yes. Again, I started this case
Go ahead, sir. Go ahead.
With the hypothesis that the Lexus didn't contact Mr. O'Keefe. And so I start what's called the null hypothesis, that this didn't happen.
So if that's where you started, why didn't we hear any hypotheses where that actually is the case? Right? I don't get that. He was very confusing with that. That made no sense. That seemed like a way to try to bolster his own testimony.
And then I look at evidence to either include or exclude the null hypothesis. So theoretically, my confirmational bias starts with a bias that it didn't happen.
Cha right. Like that's what I say. Cha right.
Can you point to one document that shows that you analyzed whether there was no contact between the Lexus and Mr. O'Keefe? Can you point to one document? Was there one document on your slide presentation that analyzed the null hypothesis as you call it, there being no contact at all? Was there any slide in your direct testimony?
So remember what I said, we start with hypothesis, we get more data, we whittle down our hypothesis to the final answer. I mean, I had 130 slides. I suspect I bored some of these people to death already. So I didn't include everything. There's thousands of photographs in here. There was a bunch of testing I did with the Lexus about backing, pedestrian detection that, removed certain hypotheses. So if I was...
So you hear I mentioned that backing, pedestrian detection, things like that. And Sean says, probably not ideal when your final witness says, these people are probably bored as hell with me. Yeah, it's probably not great, but I do think he's trying to endear himself to the jury and wait till we get to the end of his testimony. I found something very interesting that happens.
I was able to eliminate a hypothesis, I didn't present it here.
Sir, my question is not about.
All the slides show that, to answer your question.
Sir, my question is there any slide that says alternative hypothesis to, whatever the label is, whatever the term, that says no contact between the Lexus vehicle and Mr. O'Keefe? Is there any document that you presented to the jury that shows that?
Any document where those words are written on it?
Correct.
No.
And to work through
This is interesting. This is kind of like breaking news for me because I haven't seen it. Nikki said Karen just announced her first witness will be Matt DeSogra. And I believe there's a lot of names, a lot of people. I'm sure the chat can help me out here. I believe Matt DeSogra is the Shannon Burgess counterpart, which means, because, and if we can remember the line of witnesses, Burgess had to testify before Welcher. So that feels like DeSogra before ARCA, right? So it feels like they're starting out with the ARCA witnesses, the accident reconstruction, as their first set of witnesses, which I think, as we talked about earlier, if I was a betting man, I can see the for and against all these different arguments, but the odds would have to be pretty good for ARCA for that evidence to be first. And it's feels like it's writing itself like a sports movie at this point, because we are going to get like for like battle here right back to back.
hypotheses, different ones, in confirmation, and to see whether there's confirmation bias. Have you heard of scientists refer that as showing your math, so to speak, in working through hypotheses, documenting each hypothesis and how and why you rejected them? Have you heard of that term in the scientific world, show your math with confirmation biases and alternative hypotheses? Just a question. Have you heard the idiom, the phrase, show your math?
Your question is, have I ever heard show your math, period?
Associated with the application of various hypotheses to avoid confirmation bias. Have you heard of that term used in that conjunction?
Not really in that
Okay.
context. It's probably, I understand where you're going with it.
Thank you, sir.
You're welcome.
No further questions.
Dr. Welcher, you are awesome.
Oh my God, thank you.
Oh my gosh. Thank you, Your Honor. And then an audible laugh. I don't know if that was from the jury. I don't know if that was from the people in the gallery. I'm going to play it on normal speed so we can hear it one more time. Does that mean the jury liked Welcher? I don't know.
Dr. Welcher, you are awesome.
Oh my God, thank you.
And a smile from Judge Cannoni. I don't know. Did he do something to endear himself to the jury throughout these last couple days? JB, do you think the prosecution strategy was to limit the defense by not calling some witnesses because if the defense brings them, they're limited and prosecution gets advantage and cross? So the defense isn't necessarily limited if they call them, but yeah, I think that was part of the strategy. Limit the work the defense can do during your case in chief. Because he's a defense attorney, don't forget. Hi from Scotland. Watch you daily with my husband after getting him hooked on the Karen retrial. Apologies, sir. What do you think the jury thought of Welcher? And this is a great time for this question. Maybe they liked him. Maybe they were endeared to him. They laughed kind of when he said that. By the way, we are about to play the Karen Reed clip that I think is some of the best evidence for the Commonwealth. And at the end of their case in chief, I feel adamant that Hank Brennan did a great job using Karen Reed's clips. You can hate me for it. You can be mad at me for it. I can have any lawyer on this show and tell me I'm wrong about that or they don't think they were effective. To me, someone who watched the first trial, but even without the first trial, watching the second trial, to me, they were incredibly important. And I will tell you why after we watch this last clip. Let me answer a couple questions first. Get in the chat. Let me know why I'm wrong. Ask me your questions about that. That's fine. We're going to talk about that. What's the point of the data collection if not for the collisions? Well, apparently to just make a bunch of inferences, the jury can think, oh, that's when it happened. But they definitely didn't say that's when it happened because they don't have enough information to say that. Judy, one thing I missed this trial is all the witnesses saying they didn't see John O'Keefe on the lawn when they left. I think that's a big deal. What do you think? I think it's a huge deal. And I think that's part of Brennan's strategy, like the last question asked. Do you think it was his strategy to not call certain witnesses to limit what the defense can do during your own case in chief? Doc, can you tell me whose testimony said John O'Keefe was holding the glass? So if you want my opinion, I think it's Karen Reed. I think one of her video clips, because I agree, I thought the same thing at first, but I think Karen Reed's clip said John had the glass I had from the waterfall. I could be making that up, but you guys, I'm pretty sure she said that in one of her clips. CJ, do you think the defense should put Karen Reed's dad on the stand to go over a lot for Karen? He's so likable. I agree. He seems like an extremely likable man. I do not think that is I do not think that that is something that they should do. I don't. Because I think that opens up the door to some things that they don't really want to get into, and I don't think he's necessary to call. John, I have been a fan since Depp. Amazing progress. Can the defense experts rip into the Commonwealth expert reports? Rip into, you'll have to define for me. They can definitely disagree with them. They can definitely talk about why they're wrong. They can definitely talk about why they're, the way they see it is correct, and the way the defense experts or the way the Commonwealth experts see it is wrong, but we'll see how it turns out. Rebecca, Bev has said the defense can't tell the jury who hired ARCA. I find it appalling the jury can't know they were hired by a neutral third-party law enforcement agency. Can the defense mention it and she can strike it, but the jury hears it? Absolutely not. That would be sanctionable if you say it was the FBI after the judge. That's violating a court order. But I think she's still going to let them say third-party agency, maybe not law enforcement and definitely not FBI. Do you think Alessi is losing his cool about the hand gesture was hurtful to the defense? I don't think it's something that's going to be overly powerful. The jury's going to remember forever. What's up, Pete? Don't ever let the chat change you. Thank you, Anthony. And I will do my best not to. You can hold me accountable. John, so now does Hank get to put his defense attorney hat on? Yes. With the defense witnesses on cross. If so, that will be interesting. Yes, I would assume he's a very good cross examiner. That is what he does mostly now in his practice as a criminal defense attorney. And you can tell he's much more comfortable with that and how he directs. Question about constant, let him answer from the judge. If he is asked a yes or no question, the response is not, that's unresponsive, is it not? Yes, but she always lets them explain their answer. I would argue to let my witness explain their answer. They should start with a yes and then their explanation. Sometimes if you push, the judge will make them do that. How can I view your presentation or paper / conference? It's a good question. I don't know. I'll see if it is, if they're streaming it or if it's I don't know. It's for the Florida Association of Criminal Defense Lawyers annual convention. So I don't know if it's going to be streamed out anywhere. This stream should be called Daddy You Know. Oh boy. There's no proof that John O'Keefe was outside of the car at the reverse event and might still have been in the car. They were lost. Okay. So you can say you don't find the testimony credible but there is record evidence or testimony from Nagel and Levinson that he was outside the car. There was somebody inside the car when they pulled up, and they were not inside the passenger seat anymore. Karen Reed also said John got out at 34 Fairview. Now, we don't necessarily know, and then the Commonwealth would say they presented evidence that the backup event happened at the time that John O'Keefe was lined up with when Nagel said he was outside the car and last movements of his phone. We'll see. We'll see. All right. Let's listen now to the final piece of evidence played by the Commonwealth. Hank Brennan stands up, goes back to the podium, and asks for the last clip that we're going to hear from Karen Reed's own mouth, the last thing the jury hears before ending court for the day.
Commonwealth moves to introduce and play clip 26.
I've got my lawn guy right outside my door, so I'm going to hold before we play it so that I can hear it clearly, and we can talk about it. I don't know if you guys can hear, but let me answer a couple questions while we wait. Do you think the defense will call Proctor and Higgins? Proctor, yes. Higgins, I don't know. 50-50 on Higgins. Pee-wee. Can Brennan add clips from the documentaries during his closing argument? Can he use any during the defense? Thank you. Clips give me heart palpation. Can he use them during his, so you say add clips. So he can't add clips that aren't in evidence in his closing. But if he played the clips, he absolutely, I would expect him to use them in closing. Okay. That's number one. Number two, can he use them during the defense's case in chief? No. But I absolutely expect him to use some of the ones he's entered into evidence during his closing argument. Can he add any in rebuttal? I would say probably not, unless they directly respond to what the defense puts on during their case in chief. All right, here we go. Let's hear what Karen Reed has to say at the end of trial.
So I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and is.
So again, second degree to me is just so far out. There's just no way they're even presenting evidence themselves that it wasn't second degree. But how is it possible she didn't hear the backup beep? How is it possible she wouldn't know? How is it possible that she could back up and hit him and not know it? Well, she's giving all of those possibilities. So I knew this was going to come up eventually. You don't do your own lawn, Peter. It's humongous. It's humongous. I would die if I did it. There's like a whole crew of people doing it, not just one person, because it would take forever if it was one person. And I can't do it. Can't do it. I'm not good at stuff like that. I've already told you guys.
My car and I hit him in the knee and he's drunk and passed out and asphyxiated or something. And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
Ryla said she was just wondering what could have happened. Let's listen to it one more time, okay? I would agree. She's wondering what could have happened, but the Commonwealth has kind of built their theory around what Karen Read thinks may have happened. And I'll tell you, reasonable doubt, all the things we've been talking about, do they think that everybody's just roasting me for my lawn take? You wouldn't die. I have 5 acres. I do it myself. I had a feeling that was coming. I deserve it. I deserve it. Pile it on. But I think people are underestimating how important this is. I really think they're underestimating how important these comments are by Karen Read. This is what the Commonwealth wants you to believe happened. This is what Karen Read said is possible. Now we've put up a bunch of witnesses that said, we think this is probable and reasonable that this is what happened. My opinion is the jury is going to find these pretty compelling. My opinion is if Karen Read gets convicted, it will be in large part because of these videos, because of these clips. Not saying she's going to get convicted. And I think I do not have 5 acres. Somebody said humble brag 5 acres. I do not have 5 acres. I think let's get off the yard. I really think that this was the most important evidence. Now, I still think there's way too much reasonable doubt. They didn't prove any of the theories Karen Read is throwing out there. But I just wish it didn't come from her mouth. They didn't hear these theories from her mouth. If I was the defense. Can the defense play more of that clip of Karen Read explaining why she was feeling that way after Jen told her she likely hit John O'Keefe? Yes. I'm saying yes. They should absolutely be able to play that to add the context for the rule of completeness. Will the judge allow it? I don't know. If I was a juror, I would want to know what was said before and after the clips. Some jurors probably do. Some probably don't. Probably don't. Karen said Matt DeSorga will be the first witness. Thoughts? It means they're coming right out with ARCA. I wouldn't put much into the show clips when so many are cut off and modified, what people say to fit narratives or get views. My opinion, I totally disagree with this. I think every juror will consider these clips important. Now, will they want more context? Hopefully. But I absolutely think they're going to find these clips important. I've never heard a jury say, we listened to the words and voice and face of the criminal defendant, and we didn't find it that important. I've never heard a jury say that. I've heard jurors say a lot of things. That has never been one of them. Happy to listen to you live, even from my time zone. Hi from Finland. Laura, you know, and Daddy, you know, rock. Why was crash dummy drop test done on concrete? Initially, they said frozen ground. The defense can pick it apart with their experts. Neek said, I enjoy the chat, but I find the objectification of Peter to be uncomfortable. It's fine. It doesn't bother me. We move on. It's a joke for 99% of people in here. I hope. If it's not a joke, it should be. But I appreciate it. All right, let's listen to this clip one more time.
So I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out, and David said, yeah, then you have some element of culpability.
And the fact that it ended with, then David said, who they're all looking at right there, then David said, you could have some element of culpability, when her own lawyer is telling her she could have culpability. And then you're like, oh, these defense lawyers, they're coming and trying to twist stuff and trick us and smoke and mirrors and divert our attention. He knows she did it. He even told her that she's guilty. That could be the way some jurors look at that video clip. It's not good. It's not good. I'm just saying. It's not good. So much reasonable doubt. Reasonable doubt that any defense lawyer would have a heyday with, but those clips are not good for Karen Reed. The kid, did you notice Hank Brennan dyed his hair? I did not. The virtual juror, Brennan has butchered DeSogra's name, so have I, just like Alessi's, so much that everyone is now misspelling, pronouncing it. Yeah, including myself. Michelle, don't feel bad, Peter. I bet your lawn guy can't do your job either. Hey, that's right. That's how the world goes around. I love hiring people for stuff like that because I want people to hire me for their legal needs. Right? That's how the world goes around. These clips remind me of Dateline type clips. Well, she chose to do them. Make her look guilty, but at the end, the person is innocent. Be curious how jurors feel when the defense presents their case. I agree. Very interesting to hear that. Please explain why the 3-point turn plus key cycle data is put to bed. It came up again this morning, still seems unresolved. I don't know that anybody said it was put to bed. I absolutely think ARCA is going to go through that. Or maybe DeSogra. Karen Reed is speculating. That means there's still reasonable doubt. To you, to me, but to every juror, I don't know. Ben, I know you are not guilty from a legal standpoint, but don't you think she possibly hit him? So here's what I'll say. I would be basing this off of ARCA trial number 1. So I'll say right now in this case, do I think it is a possibility, just like a car shooting out into space is a possibility? Yes, I think it's a possibility. Highly unlikely, but a possibility. I do think that possibility could be completely eliminated depending on what ARCA says this trial. If I'm going to bring in what ARCA said first trial, I really don't think it's possible. I don't understand how the taillight would simultaneously explode into 50 pieces and make those cuts. Was it the part of the taillight that stayed on the car that made those cuts? Was it the exploding pieces? Was it the debris that they found in his shirt? My logic and common sense tells me I don't understand that. I can't figure out how they would make those scratches on his arm look like that. A bunch of little like red, cuts, like where glass would go in it, or, fiberglass or polycarbonate, things like that. That's what I struggle with right now. Covert. The funny thing about sensors is that can incorrect. Planes can fall out of the sky because of misreadings. Morgan, I work hard to make money to pay people to do things I don't want to do. Fair. You guys really think it's a good use of Peter's time to do his own lawn? Also fair. It would take me 50 times longer than it takes these guys. I remember getting near, pass out drunk, and have vague memories of snippets of an event. So is she envisioning bits and pieces? Potentially. I don't know. Meatball Mama. We need to get you to 500K. Get your friends, neighbors, coworkers, everyone to subscribe. Love your channel. Keep doing what you're doing. I think they were the first 63 subscribers was my friends, neighbors, coworkers. So I don't know if I have any more to squeeze out of this. Losing trust in the justice system. Don't do that. Don't do that. At least not yet. Beyond a reasonable doubt, beyond to a moral certainty, Brian. And this is what we're going to end on. So I appreciate you guys so much. I got to go. Vacation starts in about an hour. So until next time, we are out of here. Actually, Abby, let me hit this. Can someone point me to a diagram that at Cold show how she possibly was driving to have hit him like this? I can't even begin to picture it. Make it make sense. I can't point to it. Also, Ben, the 1236 is a tough one for me too. But I get what you're saying, and I think the paint test did explain how the tail light could end up on that spot. So I do get it with this trial, how it is a possibility. Let's see what the defense says. All right. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.